Start. In State of Haryana versus Janak Singh 2013 9 SCC 431, Honorable Apex Court has held that where criminal appeal preferred by the convict of offence under Section 376 IPC was not pressed by the counsel for the appellant as regards the judgment of conviction and had pressed only on the point of sentence, and the appellate court, High Court, then reduced the sentence already undergone by the convict in jail. It has been further held by the Honorable Supreme Court that even when the appeal was not pressed on merits and only passed only on the point of sentence, appellate court has to see under Section 376 IPC whether the conviction was proper. For the ready reference, relevant part of the aforementioned judgment of the Apex Court is quoted below. We notice that before the High Court, the learned counsel for the respondents did not challenge the conviction. At the same time, he stated that conviction, the circumstances of the case and medical evidence indicated that this could be a case where the prosecutrix had gone with respondent Joginder Singh or her own will. Therefore, it is not clear whether the respondents had really instructed their counsel not to press the appeal on merits or whether the counsel on his own thought that getting the respondents released on sentence already undergone by them was an easy way out, and therefore he preferred that opinion. We feel that the appeals were heard in a slip hood manner. It was open for the respondents to press the appeals on merits and pray for acquittal. Had the case been argued on merits, the High Court could have acquitted the respondents if it felt that the prosecution had not proved its case beyond reasonable doubt. Assuming the respondents did not press the appeals, the High Court had to still consider whether the concession made by the counsel was proper, because it is the duty of the court to see whether conviction is legal. But once the respondents stated that they did not want to press the appeals and the High Court was convinced that conviction must follow, then ordinarily it could not have reduced the sentence to the sentence already undergone by the respondents, which is below the minimum prescribed by law. The High Court could have done so only if it felt that there were extenuating circumstances by giving reasons. Therefore, while reducing the sentence, the High Court has merely stated that it was just an expedient to do so. These are not the reasons contemplated by the provisions to Section 376 (1) IPC. Reasons must contain extenuating circumstances which prompted the High Court to reduce the sentence below the prescribed minimum. Sentence bargaining is impermissible in a serious offense like rape. Besides, at the cost of repetition, it must be stated that such a course would be against the mandate of Section 376 (1) IPC. In view of the above, law of Honorable Apex Court in State of Haryana versus Janak Singh (Supra), order passed by Additional Sessions Judge at Chandausi, dated 3/11/2021, dismissing the appeal on the ground of not pressed by the learned counsel for the appellants, deserves to be set aside and revision deserves to be allowed. Accordingly, revision is allowed. Impugned order dated 3/11/2021, passed by Additional Sessions Judge Sambal at Chandausi, is set aside. Matter is remitted to Additional Sessions Judge Sambal at Chandausi to dispose of the matter in accordance with provisions of law, after providing adequate opportunity of hearing to the parties. It is also directed that Additional Sessions Judge shall dispose of the appeal within a period of 3 months from the date of receipt of certified copy of this order as revisionist is already in jail and matter relates to section 376 IPC